Any mention?
Lordship, I beg to mention item number 8 and 9. If I have requested my learned friend also, after 2 weeks, my lord.
It may come up immediately after the puja, Lordship. After the vacation.
After 8 and
8 and 9.
8 and 9.
One prayer of Mr. Santa Lonet, G. Lonet, additional CAG appearing for the respondents. Not objected to by Mr. Pote, learning counsel of the petition. This is matter after 2 weeks. 2 weeks, yes.
May please, Lordship. I beg to mention item number 13, Lordship. Lordship, let it come after 2 weeks, Lordship.
We have no objection, Lordship. 2 weeks on the prayer of the petition. Yes.
Deeply blessed. 13. Wait, please, Lordship. Lordship, I beg to make a mention of item 3. Lordship, this matter, I'm praying that the matter may come up after puja vacation, Your Lordship.
No objection, Your Lordship.
On the prayer of the petitioner, not objected to the learning counsel appearing with the respondents. This after 2 weeks. Yes.
Lordship, item 4, Your Lordship. In this matter, this is joint prayer, Your Lordship. No.
Is it joint prayer? Joint prayer. On joint prayer, to the parties. List after 3 weeks. Yes.
Highly obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 6, Lordship. Let this matter be referred after 2 weeks, Lordship.
Yes. Any objection? No objection. The same thing. Not objected to by science.
Highly obliged, Lordship.
May it please your Lordship. Lordship, I beg to make a mention of item number 7. Lordship, I'm praying if this matter may be listed after puja vacation.
No objection, Lordship.
Same motion.
Obliged, Lordship.
May it please your Lordship. Lordship, I beg to mention item number 16 and 17. I pray that the matter may be taken up after 2 weeks, Lordship.
You are appearing on behalf of the respondent?
Of the respondent, yes, Lordship.
Yes.
Petitioner, Your Lordship, on behalf of D. Thaba, Your Lordship.
Okay. After 2 weeks on the prayer made by Mr. Swanson, learner counsel appearing for the respondent. Yes. Yes.
Highly obliged.
May it please, Your Lordship? I beg to mention item number 10, Your Lordship. Lordship, let this matter come after puja vacation, Your Lordship.
Here for the petitioner.
Yes, Your Lordship.
Still respondents, Lordship.
No objection.
No objection.
This after 2 weeks. Yes.
Highly obliged, Lordship. May it please, Your Lordship?
Yes.
Your Lordship, I beg to mention item 11, Your Lordship. I've taken the consent of both.
Yes, Lordship. I'm for still respondent. No objection.
11.
Similar prayer for item 12, Your Lordship.
Yes.
Lordship, I beg to mention item 15 as well, Your Lordship.
Item 12. Item 12 who is there?
12, I'm for the still respondents.
There is private respondent also.
Private respondent is there.
Respondent number 4.
You do not have to lift your thing, you just say yes. Yes. No objection there also?
No objection.
Yes. This also. 2 weeks.
Similar prayer for item 15, Your Lordship. May come after 2 weeks, Your Lordship.
Yes.
Objections, Lordship.
15 also. Yes.
Highly obliged. Your Lordship, I beg to make a mention of item number 5. The conducting counsel is not able to be present today due to personal difficulties. Your Lordship, we're praying for 2 weeks' time.
You are
For the petitioner, Your Lordship.
20 also on the prayer of the petitioner. Pray. Not objected to by the learning counsel for the respondent. List of 2 weeks. Yes.
Highly obliged.
Yes.
I beg to make an unlisted mentioning of a new matter, my lords. It's a challenge to the unilateral appointment of an arbitrator. The order of the commercial court.
Arbitration is not before this.
Well, it's CRP, my lords. I have been It is a civil revision petition that I'm my lords, challenging an order of the commercial court. And my lords, the arbitrator is the arbitrator's my lords, appointment was
This will be a
challenged.
revision under 227.
Yes, my lords. 227. So my lords, my lords may have it tomorrow, my lords. I'll file it within the course of the day. Because there is some urgency, my lords.
Who will be the other side? Who is the prospective other side?
My lords, the other side is represented by Mr. B. Pathak before the commercial court. I will inform my lords the other side also.
I know. General Minister, just give a try. Let us see.
Yes,
this,
Tomorrow, my lords. Oblige me.
Supplementary causes, item number 1.
Yes. Yes.
Lordship, the petitioner is the owner of a vehicle, Lordship, which was seized in connection with a Umiam PS case number 64 of 2024. And the petitioner has filed an application before the trial court for the jimma of the vehicle, which was rejected.
This is in connection with what offence?
It is in connection with the NDPS matter, Lordship.
When was it seized?
It was seized on 24/7/2024.
2024.
24, Lordship.
So you filed an application for jimma.
Filing of the application was in the month of August 2025.
And who are you? You are the
I am the owner of a vehicle.
registered owner of the vehicle.
Lordship. 2 vehicles were seized. 1 vehicle belongs to me. So I filed an application, and it
You are
was
an accused
released-
in the matter.
No, Lordship, not an accused.
Okay, then
Then it was moved on 15/7/2025, Annexure 23. Then it was heard and wide impugned, order dated 22/7/2025. It was dismissed, rejected. At this stage, I pray that the notice may be issued.
yes. Yes.
I'll take instruction, Lordship. I'll just comply.
This is a revisional.
Revisional. Revisional.
Whether order passed by the trial court is revisable.
Lordship, this is the only remedy which lies with the petitioner.
Is this an interlocutory order or not? Order passed in jimma petition. See that?
Lordship.
It is for the state to raise and then.
Yes, Lordship. We'll see.
Mr. Upadhyay. Petition notice returnable in 2 weeks. Mr. Sheikh, Lawyer Counsel, Learned G. GA or
GA, Lordship.
appears for the
Sole respect.
respondent. Hence, no formal notice is called for. Stop. Then next paragraph, the Learned G shall obtain necessary instruction. List after 3 weeks. Yes.
Master. Obliged.
Daily list, item number 1.
Your Lordship, this revision petition is preferred challenging the order passed by the under trial court, Your Lordship, for dismissing my application, which I have filed under Order 7, Rule 11. Your Lordship, what happened here is
Rejection
that...
of plaint.
Pardon, Your Lordship?
Rejection of plaint.
Yes, Your Lordship.
Yes.
Your Lordship, what happened is that the respondent had instituted a suit against me for permanent injunction and declaration. So, Your Lordship, whereby the respondent has also prayed for entire for revocation of the registered gift deed, Your Lordship. So, subsequent to filing the written statement, Your Lordship, I preferred an application under 711, Your Lordship. So, Your Lordship, the reason that I filed an application under 7 Order 7 Rule 11 is that the petition is barred by law under Section 126 Transfer of Property Act, Your Lordship, for revocation of the gift deed, as it is being an unconditional gift, Your Lordship. So, Your Lordship, in the plaint itself, Your Lordship, the respondent had specifically...
The ground was there. It was barred
Yes,
by
Your Lordship.
application of Section 126 of the Transfer of Property.
Yes, Your Lordship. The
Reason being that the
suit was filed that on the ground that I had offered the property for sale, Your Lordship, to a third party. Yes, Your Lordship. And on that basis, they have filed a suit for revocation of the gift deed. So, Your Lordship, in the plaint itself, yes,
Just go slow.
in the plaint itself,
They prayed for, the suit was filed,
yes, Your Lordship.
praying for revocation of gift deed executed by you.
Yes, it was executed in my favor, Your Lordship. I am the daughter,
Gift deed
yes.
executed in your favor.
Yes, Your Lordship.
And then that gift deed was challenged on the ground that
That I had offered that gifted property to a third party for sale, Your Lordship.
who
Because
have offered?
me, Your Lordship.
No, but then you received it just by recently only by the gift only. Before that, you could not have offered it.
No, Your Lordship.
Then
So, Your Lordship,
no. Just let us be clear.
yes, Your Lordship.
So far as the fact is concerned,
Yes,
you
Your-
received the gift, isn't it?
I received the gift, I registered it, and there's no...
You registered it.
Yes, Your
It
Lordship.
means like the suit property was bequeathed to you by way of a gift deed, by a registered gift.
Yes, Your Lordship.
So only after the registration, after the acceptance
Yes, Your
of the
Lordship.
gift,
Yes, Your Lordship.
you become the owner of the property,
I
isn't
become
it?
the owner, yes, Your Lordship.
Now thereafter, you make an undertaking or agreement to sell the property to somebody. Is it something like that?
It's just a purported claim by them, Your Lordship, that I
No, is
offered
it-
for sale.
Forget about whether it's correct or not.
Yes, Your Lordship.
But then the claim is that thereafter you agreed to sell the property
Yes, Your Lordship. What
to the
happened?
plaintiff. Is that the fact?
No, Your Lordship. The plaintiff is my mother. She has gifted me the property.
Okay.
And after I received the property, I offered for sale.
You offered it for sale.
Yes, I
To
offered
whom?
to a third party, Your
Okay,
Lordship.
okay.
To a third party. Then on that basis, they have filed a suit challenging that
Who filed the suit?
my mother, who had bequeathed the...
Your mother has gifted it to you.
Yes, Your Lordship.
And then she has filed a suit.
Filed a suit against me, challenging that the gift deed it's praying for that the gift deed is being null and void. Yes, Your Lordship. And on that basis, Your Lordship, the suit was challenged under Order 7 Rule 11, being that in the plaint itself they have stated that there were no written express condition in the gift deed itself, Your Lordship. So it was just a verbal agreement which they purported that it was agreed that it should not be offered to a third party.
So there was no condition attached.
No, Your Lordship. There's no condition, express condition in the gift deed itself. And in the plaint also, Your Lordship, they have categorically
Then-
stated that it was just a verbal agreement that
No, but
it should
then
not
does it
offer
become
for...
a ground for consideration under Order 7 Rule 11?
Yes, Your Lordship, because
That
it's-
whether there was a precondition attached to the gift or not.
Your Lordship,
Is it not that it becomes a matter of evidence?
Your Lordship, because in the plaint itself they have categorically stated that it was just a verbal agreement not to sell it to a
See,
third party.
what do you see at the stage of Order 7 Rule 11? We see only the plaint. We cannot even
Yes, Your Lordship.
see what stand you take. We do not look at the written statement.
Yes, Your Lordship.
We do not see what averment you have made in the Order 7 Rule 11.
Yes,
Your application for the Order 7 Rule 11. Only what is required to be seen is the plaint. If there is no disclosure of any cause of action in the plaint, then only.
In the plaint itself, Your Lordship, they have stated that the the agreement was just a verbal agreement not to sell to a third party. There's no express
So that
condition
is
in the
okay.
agreement
So that is
itself,
at least something is there.
Yes, sir.
So whether verbal or not, that will be proved during the course of the evidence.
Your Lordship, because on the Order 7 Rule 11
At least there
clause,
cannot be a rejection on the basis of the statement made in the plaint, isn't it?
Yes, Your Lordship.
No, that is the subtle thing. That is what you require in Order 7 Rule 11.
Yes, Your Lordship. As per
That if the suit is barred because of any statement made in the plaint.
if Your Lordship can come to page number 21, Your Lordship, of the plaint.
Page 21.
Yes, Your Lordship. This is a plaint, Your Lordship. Paragraph number 10.
Yes.
The plaintiff begs to state that soon after the execution of the said gift deed, dated so and so, the defendant's malified intention and ill motive started to showing when she offered the said suit land for sale without taking into consideration the verbal assurance and promise that the defendant shall not sell the said suit land to anyone whatsoever, and that the legal heir of successor of the defendant's children shall inherit the same in the future as the legal and lawful owner. There, Your Lordship, it has been specifically stated that it's just a verbal agreement, Your Lordship.
So it's okay.
Section 126 Transfer of Property Act clearly states, Your Lordship, when and how the suit should be revoked or suspended, Your Lordship. There should be an express condition, Your Lordship, in the gifted property itself. And
Yes, but then there can be express condition, means it can be verbal also. Verbal doesn't mean it is implied. Verbal can be express.
Your Lordship, there are some judgments also which states that there should be.
See, to
some
what
express
extent we can
conditions.
go, we can examine. Anyway, we'll issue notice, but then
Yes, Your Lordship.
we have a difficult matter. Yes. Heard, Mr. Your name, please?
R.S. Manian.
Learning counsel for the petitioner. Issue notice, returnable in 3 weeks. Petitioner shall take steps for service of a notice upon the sole respondent within 2 days. List after 3 weeks. You take steps within 2 days.
Yes. Hello.
Item number 2.
Yes, Mr. Sangma.
Yes, on the last occasion, the respondent.
Oh, that is the
yes,
condemnation.
no, quarrel with the calculation, but we were asked to bring the judgment, Your Lordship. I'm bringing the judgment to support my case, actually, Your Lordship. This is,
It's okay. First, you just give us the fact. Okay.
yes, the fact of the case is, Your Lordship, that this instant, I filed this instant miscase application to reinstate the petition which has been dismissed for default, Your Lordship.
For restoration.
Yes, for restoration. And then there was delay, actually, that some delay was there, but then that COVID part, that's as per the Supreme Court judgment, that has been excluded. Now, going by the petition, as per the calculation of my petition, which I have prepared the chart also, there is the total delay, excluding those COVID 19. The delay was at around 753 days, my lord. So,
Okay.
and then the learned friend also have agreed to the calculation. Therefore, now in this petition, Your Lordship, I have explained the reason for delay
It means delay is more than 2 years.
yes, for about 2 years.
Yes.
And then I have given some explanation, Your Lordship, regarding the delay of 753 days, Your Lordship.
What is the period of delay starts from which date?
The period of delay start from, Your Lordship, that is the event and the balance content. Date of event. I have mentioned here. It would start period
From 29th May 2022,
Yes, Lordship.
isn't it?
Yes, Lordship. That yes, will start from 29 May 2022. Actually, I calculated 30 May 2000. Yes, but actually, Yes. For my calculation, it will start from 30 May 2022. That was my calculation actually. 29 is only one discrepancy.
The
Excluding all the
exemption is till 28 to 2022,
yes, Lordship.
isn't it?
Yes.
And then plus 90 days.
Yes, plus 90 days.
It comes to 29th May,
Yes.
28th May, and then limitation starts from 29th May. Anyway, you say it will start from 30th May.
Yes.
Okay.
29. Yes, Lordship.
Okay, no, 30th May. It's all right.
30th May. Yes, 30th May
Yes,
2000.
30th May. Yes, yes, you're correct. 30th May. Now limitation starts from 1st June or 30th May. 30th May.
38 May. My
Okay.
To start from 38 May, and then excluding the 90 days. Yes. Now, Lordship, in this, which earlier I have submitted one chart where I have mentioned
You
that
filed your restoration application?
I filed my restoration application on 21st June 2024.
Okay. Okay, 700. So you have to explain the delay, isn't it?
Yes, Lordship.
Now, from 29th May 2022, where is the explanation of delay in your petition?
Delay in my petition, my Lord, my application.
Which paragraph of your petition shows that part?
But in the petition, that there was calculation was wrong. But I have explained the delay actually, since there was a miscalculation. Therefore, court have asked to recalculate. So I prepare that. But in the petition, I have mentioned some delay. The reason for delay, Your Lordship.
Where do we get it?
Yes. Let's see that. There in the para, it start from para 22, then also 24.
Para 22.
Yes, Lord.
Let us see what you have written there.
This is actually this calculation, Your Lordship. That,
No, but then where is the explanation
Yes,
of delay from 30th May 2022?
Para 24, sub-para I have given, Your Lordship.
Yes, okay.
I read it, Lordship. That the humble applicant petitioner also beg to explain the period of delay in specific manner as follows. That from the dismissal of the repetition, repetition number 103 of 2017 till the filing of MCW 181. Earlier, this application was filed, Your Lordship. It was withdrawn, then again refiled. So that explanation I have given. There was a delay of
Earlier application means case number 181.
yes,
That was earlier.
earlier. Those things also I have
Okay.
explained. Was delay of 890 days, because that calculation actually is wrong. But however, I have explained in this petition that was dismissed, and the restoration application was supposed to be filed within the period of 30 days. That is, period of 30 days expired on 01/03/2021, but the appellant has filed the application only on 18/8/2023 after the delay of 898 days. That from the filing of the miscase WPC 181 till the withdrawal of MCW 181 of 2020, there was a delay of 238 days. The application for restoration was filed on 18/8/2023 and was withdrawn on 12/4/2024. That from the withdrawal of the application, the
Now,
restoration.
whether you are entitled to get this period condoned.
No, actually, this is the period which Spain actually was pursuing before the court. Actually, they were genuinely pursuing.
You have withdrawn it.
Yes.
So,
Therefore, that my contention, since I have been genuinely pursuing the matter on those days, but I have just explained why delay has been filed. Actually, the earlier petition, I've spent some time in the court, so that is the explanation I've given you, Lordship. So there is a provision also, Your Lordship, in the, I think in the Limitation Act, section 17 or 14, where it's
That is so far, it has nothing to do with condonation.
yes,
That is the exemption.
yes, exception.
You are not seeking exemption here. There are two different aspects. One is to seek condonation of delay, and second is the period of exemption.
Yes,
Now, if you see that, if you had to say, if your contention is that this period is to be exempted, then there is no requirement for you to come and make prayer for condonation of that period, because that is exempted. That stands excluded by operation of law. So that is, if that is the case, then that explanation is not needed. But then you yourself, you are offering that explanation.
yes, Lordship. That,
Then, so section 17 will not come to your rescue.
yes.
Anyway, it's okay. It's okay. Then, okay.
Yeah, and then the Lordship,
Let us first see whether what is the explanation. Then we'll come to the validity of the explanation.
yes. Now that is explanation, but prior to that also regarding the, I have given in the reason for delay also is there in the para 13.
No, but then anyway, this okay. This is, if we accept this covers you the period from 18/8/2023 to 12/4/2024.
Yes, Lordship.
Okay, but then what about the period prior to it?
Yes, prior to that para
That means the period from 30th May
yes, this in para
22, yes, till 18/8/2023.
yes, this para 12, 13 and 14, Lordship, I have 13, 14 and 15. Lordship, I have make some explanation, Your Lordship, in my miscase application prior to that period. Para 13 also mentioned that, however, the extreme financial constraint coupled with the otherwise poor financial condition of the applicant, they had to avail the help of the family members and relatives for financial support, and finally help of the Mahari, also the relatives of the applicant. The money required for minimum expenditure was arranged sometime in the year of October 2022. The 14 also I have given some explanation, Lordship, that that thereafter, in most unfortunate turn of event, the applicant number 1 fell ill due to old age in November 2022, and only recovered after considerable time and treatment of about 4 months, that is with effect from that is in the month of March 2023. Your Lordship, the 15, there's some explanation I have put, Your Lordship, that thereafter in April 2023, the application came to Shillong and met their counsel. However, inadvertently, some relevant documents, including the copy of the petition, were not handed over, as the same was misplaced by the applicant due to bona fide mistake. That's accordingly, they said documents were applied for from the registry of this honorable court, and the same was duly received in the July 2023. That after 17, that after having received all the relevant documents, the council took some about 2 weeks to prepare the draft appropriate application for restoration, and the same was filed before this honorable court on 8/2023, registered case number 181 of 2023. Because that was actually then after that remaining delay was was spent while pursuing the matter of MCW 181 of 2023, my Lord. Lordship, I have brought some judgment, Lordship, which you would like to rely, Your Lordship.
Then what about your delay after 12/4/2024?
12. Yes, that delay, Your Lordship, after 12/4/2024, they start in the para 3/24, I have stated, date of withdrawal of the application for restoration till the filing of the instant application for restoration as on 21/06/2024. There was a delay of 70 days. That is to say that application for restoration was withdrawn on 12/4/2024 and the instant fresh application for restoration was filed on 21/06/2024. Therefore, the actual delay was 1,206 days, but excluding the period with effect from so and so, which is equal to 715 days for the purpose of computing
No,
of.
but then where is the explanation? What is the explanation of delay of that 70 days?
Yes, that is here I mentioned, Lordship. The 70 days. That is to say that the application for restoration was withdrawn on 12/4/2024,
Yes.
and the instant fresh application for restoration was filed on 21/06/2024.
Yes. So where is the explanation of delay of that period? You were ill, did not have money, you were out of station. Where is that?
The delay from after 12/2024, 12/4/2024 was that delay was pursuing before the court, Your Lordship, when it was earlier and earlier in
See, this pursuing means you have withdrawn this matter on 12/4/2024,
Lordship.
isn't it?
Lordship.
And subsequently filed another application on 21/6/2024
Yes.
after the period of 70 days. Now, where is the explanation of that delay of 70 days?
Yes, that's needed. Lordship have taken some time in. Of course,
Where
here
is that
it's not
explanation?
mentioned. This one there was taken some for applying the certificate copy of the
Yes,
case
where
which
is-
was
where is
withdrawn
that?
then done.
Where is that?
Of
Where,
course,
where you have said it?
Lordship, that of course was not mentioned here, Lordship.
Where it will be mentioned then?
It should have been mentioned, Lordship. In my church, my chart sheet which I prepare, there I have mentioned in para 4, sub para 2.
Where?
In that earlier I have given this
No,
delay.
you have to make explanation in your petition only, not anywhere else.
Yes, Lordship.
It has to be supported by an affidavit, isn't it?
Yes, Lordship.
So far as your petition is concerned, there is no explanation of that 70 days.
Yes, Lordship. I agree.
Even if we accept the other's explanation, other explanation, isn't it?
Yes. Yes, Lordship. That's 70 days of. I should have.
And so far as your statement in para 12, 13, 14 is concerned, these are not supported by any proof, documentary proof, isn't it?
course, the documentary proof, Lordship, is true. There is no support. But this lady, actually, the petitioner, actually, they didn't go to the hospital. They were treating with this local medicine, it seems. Local medicine. Like, they don't go to the doctor, you know. That's why.
Where do you say he was on a local thing? Do not say any of that local treatment also, isn't it?
Yes, Lordship.
Now your para 15, April 2023 you came to Shillong to meet your counsel. But then you forgot the documents, writ petition. Isn't it?
Lordship.
And then those documents were applied and you obtained it in July 2023.
Lordship.
May, June, July. April, May, June, July. It took you more than 2 months. Now, where is that evidence that you applied it? Where is the counterfoil of your copy application form?
It was given on.
Have you given anywhere?
19. I got the repetition on 19/7/2023, my lord. This is which we got it from the registry, and we copy on 19 June 2023.
19 June 2023.
Yes.
But then you say you have received in the month of July 2023 in your petition, paragraph 16.
Lordship, there is a mistake, Lordship, actually.
What's the problem? How many mistakes? And how many mistakes you can condone? You are offering your explanation of delay.
Yes, July, Lordship, July. July only.
No, but then when did you apply?
19 July 2000.
When did you apply?
That application, Lordship. Where is that application to you? I forgot. When we applied this one. That application form, Lordship, it's not here. The form. It's not given. The order is to write.
There are two applicants in this case, isn't it?
Yes, Lordship, two applicants.
Then
Mother and
the willness is only with regard to applicant number 1. What about applicant number 2?
Because they were together, Lordship. That's why the son also.
Together means both are ill.
Actually, the mother was sick, therefore they wanted to apply together.
Son also became sick. Is it?
Son actually lost. Actually, they were
Mr.
waiting.
Sama, the problem is the delay is for a huge period. See, even after excluding that period, which is exempted by the apex of judgment because of COVID, there also you see there is a delay of more than 2 years. Otherwise, it's a long delay. Now that is where you see court has to be a bit strict, because if you see the recent decision of apex court, now condemnation is something not very easy, like what you say, like you see the merit of a case and condemn. It is not that.
I agree with Lordship.
So this is only your explanation. What more you have?
I have some decision, my lord, which I like to place, your Lordship.
It says that no explanation is needed.
No, it is given, Lordship.
Yes, decision by the Supreme Court.
Yes, it is from the Supreme Court.
Yes.
I have
And what does it say?
rely on the para 5. This one is 2023 volume 18 Supreme Court cases 764 2023 SEC online. This one is there, Lordship. There.
This is 764, yes.
Yes.
This is paragraph, which para you are relying?
Your Lordship, it is entire para 5, Lordship. Yeah, as mentioned the. May I just read it, Lordship? This court is para 5. Para 5.
Yes.
This court in Collector LA versus Katiji has been here as herein under SCP 108 para 3. The legislator has conferred the power to condone the delay by enacting Section 5 of Indian Limitation Act of 1963 in order to enable the court to do substantial justice to parties by disposing of matter on merit. The expression sufficient cause employed by the legislator is adequately elastic to enable the court to apply the law in meaningful manner which subverts the end of justice, that being life purpose for existence of institution of court. It is common knowledge that this court has been making a justifiably liberal approach in matter instituted in this court, but message does not appear to have percolated down to all other courts in hierarchy. And as such, a liberal approach is adopted on principle, as it is realized that the ordinary litigant does not stand to benefit by lodging an appeal late. Refusing to condone delay can result in a meritorious matter being thrown out at the very threshold and the cause of justice being defeated. As against this, when delay is condoned, the highest that can happen is that a cause would be decided on merit after hearing the parties. Everyday delays must be explained and does not mean that pedantic approach should be made. Why not every hour's delay, every second's delay? The doctrine must be applied in a rational, common sense, pragmatic manner. When substantial justice and technical considerations are pitted against each other, course of substantial justice deserve to be prepared for other side cannot claim to have vested right in injustice being done because of non-deliberate delay. There is no presumption that delay is occasioned deliberately or on account of culpable negligence or on account of malafide. A litigant does not stand to benefit by resorting to delay. In fact, he runs a serious risk. It must be grasped that judiciary is respected not on the account of its power to legalize injustice on technical ground, but because it is capable of removing injustice and expected to do so. Making justice-oriented approach from this perspective, there was a sufficient cause for condoning the delay in institution of the appeal, Lordship. Then, Lordship, another judgment, Lordship, I have. This is one. This another one is that is in page 19, para 44. Only just para 44.
What is the citation? Just read the citation.
Yes, this citation. Yes, citation. This is Supreme Court 2003, Volume 2, Supreme Court cases 577.
Para?
It is para is 44, my lord. Only just 44. 44, para 44. The page 19. The page is written very small, Lordship. It is very small. It's written that page.
Yes, para 44.
Yes, Lordship. the Section 5 of the Limitation Act read as the extension of prescribed period in certain cases. Any appeal or any application other than an application under any of the provision of Order 21 of the Code of Civil Procedure 1908 may be admitted after prescribed period if appellant or the applicant satisfy the court that he has sufficient cause for not preparing the appeal or making application within such period. 45. On perusal of the said section, it is evident that the question of application of Section 5 would arise wherein any appeal or any application may be admitted after the prescribed period if the appellant or the applicant satisfy the court that he has the sufficient cause for not making the appeal or application within such period. Others are not relevant.
So what do you get from here? That is what Section 5 itself says, nothing else.
Yes, only that. But I'm on this what earlier the para 5 sub number 2 of the judgment which I have earlier read, where I would like to basically relying on that, Your Lordship, on 2023 18 volume 18.
Second judgment has nothing. It is only,
Here it says, Lordship, the refusing.
The part which you have referred only speaks of the contents of Section 5 of the Limitation Act, nothing else.
Yes, is that one? Yes, but I'm not insisting on that judgment, but on that which I have relied on earlier, Your Lordship, before that para 5, sub para 2, Lordship, refusing to condone the delay can result in a meritorious matter being thrown out at the very threshold, and the cause of justice being defeated. As against this, when delay is condoned, the highest that can happen is that the cause would be decided on merit after hearing the parties. Only that, Lordship.
So you want to say the substantial justice will proceed over the technical part.
Yes, Lordship, because I'm saying that if there is a merit on the.
So once there is a merit, so delay part basically should not be taken that seriously, isn't it?
Lordship,
that is what you want.
That is my contention.
How do you know you have merit in your case?
No, if we go by the writ petition, I can satisfy. I can assist the court because.
Is it not required for you to show at this stage?
Therefore, my lord, since yes, Lordship, that it will be premature because now, unless this application is allowed, I will not be able to place the merit of a case. Therefore,
but then, if you want that merit should, if your submission is that the merit should proceed over the other technical aspect, then the court must know about the merit of the case also, isn't it?
Yes, Lordship.
When your case was, the suit was dismissed? Oh, this writ petition was dismissed?
It was dismissed on, my lord, it was January 2022. It was dismissed. Yes, 1st February 2021.
This Limitation Act applies to writ petition.
Lordship, this is because this was dismissed on default for non-appearance, and then should have come and we should supposed to file within 30 days.
What is your stand? Whether Limitation Act applies to writ petition?
Not exactly the writ petition, but and since in this in this application is because I have come and there is a delay in filing the application for restoration. Therefore, the Limitation Act is very much applicable, Your Lordship. Otherwise, there is no any other
If
provision.
it doesn't apply, it helps you, then you do not have to file even an application under section 5.
Yes.
Because then there will be no bar.
Yes, if the petition could have been filed within that prescribed period of 30 days, then I should not have taken the plea and filed an application.
According to you, the 30 days period will apply. That limitation of 30 days will apply in your case also.
Yes.
Even to a restoration application in a writ petition.
Yes.
So there is no problem. All right. Okay. Yes, Mr. Sangareshu.
My Lord, if there is a sufficient explanation, I would not oppose this application. Here is a party who failed to derive the benefits of the grace period given by the Supreme Court. Now, excluding Supreme Court order, also, Lordship has pointed out more than 2 years. Delay is there. And that is available, if Lordship kindly see, page number, para 7 of his application. Para 7, I'll just read out few paragraphs and show.
1 minute, Mr. Sangareshu.
So in para 3, he said that writ petition was dismissed on 1st February 2021.
Para 3.
Para 3. And he came to know this throughout the council after 10 months. That is available in page para 7. Lordship, can you see? Para 7, he said, after due deliberation owing to the impending situation, the applicant engaged another counsel in the second week of January 2022, so as to ascertain the status of the matter and inform the same to the applicants, and thereafter pursue the matter, such. So this more than 10 months he came to know throughout the lawyer. And para 7, he said that his newly engaged counsel checked in the CIS and came to know that it was dismissed on default. Now, para 9, he said that thereafter he came to Shillong all the way from Karo Hills and met his counsel on 30 January. So in the month of January, he was active. She was active. She came to Shillong and met on 30 January 2022. And accordingly, after deliberation, the applicants decided to file an application before this court for restoration. So that was the decision January 2022. Then there was a gap of more than 1 year. Now, my Lord, kindly see para 11. He said that there was a meeting held in the Nokma. Para 11.
Yes.
Meeting was held on 3rd May 2022. And he filed the application. My Lord, kindly come to para 15. Thereafter, in April 2023, that is after 1 year, the applicants came to Shillong again, met with his counsel. However, inadvertently, some relevant documents, including the copy of the writ petition, were not handed over, as to the same was misplaced by the applicant due to bona fide mistake. And he applied for certified copy, para 16, received in the month of July 2023. And he filed the rest, para 16 of his application.
Yes. July, yes.
And para 17, lastly, he said, after having received all the relevant documents, the council took about 2 weeks to prepare draft the application for restoration, and the same was filed before the Supreme Court on 18/8/2023.
So his own statement appears to be contradictory.
And this too, he filed after 1 year. He filed this application, first restoration application, after 1 year. When we read this, you know, kindly see. Para 9.
No, he probably it is 18/8/2023. He refers to the first petition which is withdrawn.
Which he filed. So after 1 year, he filed after 1 year. And he filed listed before the Supreme Court without annexing the Supreme Court order I brought that this was it your advantage, take the benefit of that one, exclude. So he withdraw that one. Okay. Allow me to withdraw the application.
In the earlier case, basically he wanted that period, which was exempted by Supreme Court also, to be condoned.
Earlier also, he did not seek exemption. Exemption.
So after you pointed it out, he withdrew this.
He withdrew that one. Let me take the benefit of Supreme Court grace period. So Lordship allow him to withdraw it and file the second application, which is Lordship is considering now.
There also he filed after 70 days without any explanation.
Yeah, without explanation. Now, therefore, primarily, my lord, for the time leaving aside the 71 days, that 2 years there is no explanation, and only the possible explanation taken by my learned friend is that financial crunch, financial difficulties. It is a dogma. I would understand if there one litigant is there, a rusted villager, unable to come. These are the proper reason. But it's a dogma. It's a one of the arguing. So financial constraint cannot be the ground. Number two, and Lordship, he was fallen ill. It is not.
Nakma is the head of the clan, isn't it?
He is the head of the clan.
So the question of financial crisis doesn't.
Mahari, all the members are there. And he is filing one restoration application. And he said that he was ill, but there is no evidence of. So when he applied certified copy, he did not. There is no explanation at all. And here the respondent has been functioning as a Nokma for quite a long time. And place only one judgment. I do agree, my lord, that the procedural law is a handmaid of justice. Unnecessarily, I will not oppose it. But if there is a case where the litigants is lethargic, full negligence, fail to take our prompt steps within reasonable time, and Lordship will kindly consider this judgment. This is 2025 1 ECC. The principles are reinforced in this judgment. Page number 6.
There are some recent judgments.
Yes.
Probably
also,
this year also.
Yes. This also 2025 1.
Yes.
ECC.
Okay, this is 2025.
Yes. One of the recent judgments. May I take straight away to para 20. Para 20 and 23 may I take. Running page 632.
Yes, para 23.
Para 20.
Para 20.
20 and 23.
Yes.
May remember. Be that as it may, on account of liberty having been granted to the appellant to pursue his remedy in accordance with law, yet another OA number Sansat 2020 along with the application for conversion of delay came to be filed. The delay was not condoned by the tribunal on the ground that it was filed more than 1 year after the impugned order came to be passed. No litigant stands to benefit in approaching the courts belatedly. It is not the length of delay that would be required to be considered while examining the plea for conversion of delay. It is the cause for delay in which has been propounded will have to be examined. If the cause for delay would fall within the four corners of sufficient cause, irrespective of length of delay, same deserves to be condoned. However, if the cause shown is insufficient, irrespective of the period of delay, same would not be condoned. 23 may take. If negligence can be attributed to the appellant, then necessarily the delay which has not been condoned by the tribunal and affirmed by the High Court deserves to be accepted. However, if no fault can be laid at the doors of the appellant and cause shown is sufficient, then we are of the considered view that both the tribunal and High Court were in error in not adopting a liberal approach or justice-oriented approach to condone the delay. This court in the case and such. Incidentally, this point of delay latches also raised before the High Court, and on this score, the High Court, relying upon the decision of such case, observed that it is an inflexible rule that whenever there is delay, the court must necessarily refuse to entertain the petition filed after a period of 3 years or more, which is the normal period of limitation for filing a suit. Mumbai High Court in Sanson's case stated that the question is one of discretion to be followed in the facts and circumstances of each case, and further, the real test for a sound exercise of discretion by the High Court in this regard is not the physical running of time as such, but the test is whether by reason of delay there is such negligence on the part of the petitioner so as to infer that he has given up his claim, or whether before the petitioner has moved the writ court, the rights of third parties has come into being, which should not be allowed to be disturbed unless there is a reasonable explanation. Delay. Here exactly, my lord, is not running of time, but it is a sufficient explanation. But there is no sufficient explanation. Is my humble submission. It's a clear indication that they have given up already, and they come belatedly and without explanation. So this is my humble submission. Application deserves to be declined to be accepted by the scholar court. And my lord has pointed out Limitation Act is not applicable, though my esteemed colleague has quoted that one.
He's not disputing the fact that is what
Yes.
is a part
Exactly.
which requires some consideration.
Right.
So whether we are strictly guided by the provisions of Limitation Act.
Right. Yeah, the principle of delay in latches apply here.
That is what. But then even since this application is filed under Section 5,
Yes, yes.
so we have to deal it
Yes.
in accordance with the law.
Give the
Yes. What more you want to say?
Lordship, my learned friend is saying that due to financial constraint, it is the financial constraint that Akang Mahari does not mean they're having money. That's that submission, the Lordship, I objected because Nokma or Headman does not mean they're having the financial condition. That we cannot generalize. There may be some Nokma having a good financial condition. That cannot be, but my learned senior is saying that the explanation of zero on the ground of financial crisis is not accepted. He also, there is no evidence to prove that the person is just a poor cultivator, farmer. So we cannot expect her to become financially sound.
Cultivator farmers, there are huge, rich cultivators are there.
In terms of land, of course, but in terms of money.
In terms of money, in terms of bank balance, in terms of real estate, even imported car. Have you said anywhere that your Nokma is the poorest of poor Nokmas? No.
Of course, I did not make a statement, but I have stated that financial constraint, and she was really suffering from sickness. So maybe that explanation may not be so articulate in a specific way, but I have given some explanation. But may not be each and every delay. It's not possible, but I have make an effort to explain the genuine reason he has given. And one of the important thing is that we could not. He's the quality never access to mobile phone and even this news of dismissal on T4 somehow after quite many years only she got the receipt. Therefore, that is unfortunate event happened, Your Lordship. Therefore, my only humble prayer, of course, I admit there is some defect in explanation and in filing petition, but I have given my level best to explain some sort of delay. Even my friend also had one with it.
Okay, we'll pass order.
Lordship.
Now there will be no time to pass order.
Yes, Lordship.
Just send it to my room, this book also.
Hearing item number 18.
Much blessed, Lordship.
Yes.
Lordship, on the last occasions, I have pointed out that there is no dispute between the parties as regards the award of simple interest. I admit, and he also admits, that tribunal has awarded the simple interest. Now, the point of dispute between the party relates to the phraseology used in the award and the related orders passed by the commercial court on a stay application. And that what meaning should be assigned to the word amount awarded. Your Lordship will just come to paragraph F of the award, which we have read on number of occasions. Page 68. I just take to your Lordship the interest component. We also award, in between your Lordship, page 68. We also award and direct that the respondent shall pay simple interest at the rate of 12% per annum on the awarded amount of rupees 1,26 lakhs so and so against claim number 1, 2, 3, 4, 5 and 6 and on awarded amount of rupees 5 lakhs 32,096 against claim number 7 from 5/7/2013 and from 21/3/2015 respectively, being the dates of submission of SOC for claim number 1 to 6 and claim number 7. This, your Lordship, relate to pre-award interest. We have no dispute with regard to the pre-award interest. The dispute is only with regard to the post-award interest. Now, according to me, for the purpose of the post-award interest, the principal amount and the interest accrued thereon prior to the award is to be clubbed together. And post-award interest as awarded by the tribunal should be on the aggregate of the principal amount as well as the interest component. Whereas their case is this, that for the purpose of post-award interest, it should be only on the awarded amount. Here they are reading the awarded amount as principal amount. My learned friend trying to incorporate the what's principal amount in the award, which are not at all there. The award says awarded amount. Now, what is this awarded amount? According to me, it is the principal plus interest accrued. And it is on the aggregate of these two that post-award interest is to be calculated. And again, your Lordship will find a difference. That
go by your saying also, if you see that.
Lordship.
Now, it's a respondent shall pay simple interest at the rate of 12% annum on the awarded amount of rupees.
Yes.
That is
1 crore 27.
And then subsequently again it is awarded amount of 5
yes.
lakhs 32,000.
Yes, Lord.
Now, is it not that by reading this we understand this, the awarded amount is the aggregate of these two amounts?
Yes, we understand.
Then how interest
and this is
included?
This is, your Lordship, by operation of the law. And the judgment of the apex court in Hyder construction and UHL case, which has explained section 31(7)(a) and section 31(7)(b), Now, Lordship, prior to the passing of the amendment, what was the law? If your Lordship, I may take to your Lordship the law which was prevalent prior to the amendment was the law as was laid down by the Apex Court in S.L. Arora's case, your Lordship. I just take your Lordship to the S.L. Arora case. Your Lordship, I have given compilation of the judgment.
Yes.
Paragraph 18.
There are 18.
Page 9.
Yes.
Page 9. Section 31(7) makes no reference to the payment of compound interest or payment of interest upon interest, nor does it require the interest which accrues till the date of the award to be treated as part of the principal from the date of award for calculating the post-award interest. The use of the words where and insofar as an arbitral award is for the payment of money and use of the word the arbitral tribunal may include in the sum for which the award is made interest on the whole or any part of the money. In clause A, the use of the word a sum directed to be paid by an arbitral award shall carry interest. In clause B of subsection 7 of section 31, clearly indicate that the section contemplates award of only simple interest and not compound interest or interest upon interest. A sum directed to be paid by an arbitral award. This is important, Lordship. A sum directed to be paid by an arbitral award refers to the award of sum on the substantive claims and does not refer to interest awarded on the sum directed to be paid by the award. So, Lordship, this was the law which was prevailing.
Which excluded interest.
Which excluded interest. They said that for the purpose of calculating the post-award interest, it is only the awarded sum that is to be taken into consideration, your Lordship. This was the law. There is no dispute about this.
Yes.
Now, thereafter, your Lordship, this position of law was the subject matter of the Law Commission discussions, and the amendment were introduced, and those things came for consideration in Hyder consulting case. Your Lordship, this is the main case. It's a three-judge case.
S.L. Arora was by two judges.
Pardon, sir?
S.L.
Arora was by two judges. Your Lordship, page 26 of my compilation.
Yes.
S.A. Bobde, Justice. Yes. I am coming to paragraph 2. It is not possible to agree with the conclusion in S.L. Arora case that section 31(7) of the Act does not require that interest which accrues.
You are reading?
I am reading paragraph 2.
Yes.
It is not possible to agree with the conclusion in S.L. Arora case that section 31(7) of the Act does not require that interest which accrues till the date of the award be included in the sum from the date of award for calculating the post-award interest. In my humble view, this conclusion does not seem to be in consonant with the clear language of section 31(7) of the Act. Paragraph 18 goes here. Paragraph 18 goes by the paragraph 2 of the Hyder construction case. Now, paragraph 3, Your Lordship, just quote the section 31. Then I come to paragraph 4. Clause A of subsection 7 provides that where an award is made for the payment of money, the arbitral tribunal may include interest in the sum for which the award is made. In plain terms, this provision confers a power upon the arbitral tribunal while making an award for payment of money to include interest in the sum for which the award is made on either the whole or any part of the money and for the whole or any part of the period for the entire pre-award period between the date on which the cause of action arose and the date on which the award is made. To put it differently, subsection 7A contemplates that an award inclusive of interest for the pre-award period on the entire amount directed to be paid or part thereof may be passed. The sum awarded may be the principal amount and such interest.
Just can you hold it for a moment? What is meant by this? To put it differently,
Lordship.
Section 7 contemplates that an award,
Lordship.
inclusive of interest
Lordship.
for the pre-award period,
Lordship.
on the entire amount,
Lordship.
directed to be a part thereof, it may be passed.
Yes.
Now the word may be passed.
Yes.
It is not that just because interest is given.
Yes.
That
So,
will automatically get
your
included.
Lordship, the pre-award interest is absolutely upon the discretion of the
Exactly.
tribunal, and it is also subject to the contract agreement. If the contract agreement entered between the parties says that no interest is payable, then no interest can be awarded. So far, the
Exactly. But
pre-award
say,
interest is
take as a case. We are not dealing with a case where no interest was awarded.
Interest was awarded.
Admittedly, interest was awarded.
Yes.
But then whether it will form a part of the principal award or not, that is the question.
Yes,
That is the only
that
point
is
of
the
controversy.
question, Your Lordship.
That is the only question.
Yes,
of controversy.
for the purpose of calculating the post-award interest, whether principal plus interest accrued prior to the date of award should be clubbed.
Yes,
or
that
not.
is what. Now, say supposing if the award
Lordship.
is not specific
Yes,
to that aspect,
yes,
now can we say it is by operation of law it will be included?
yes, Lordship. If it is silent, then by operation of law,
Because,
this
see, the award-
this amount even can be claimed at the execution proceedings. Even if the award does not say,
That is what you need to establish. Once you establish that, then you have.
yes,
Okay. Yes, please.
yes, Lordship, the sum awarded may be the principal amount and such interest as the arbitral tribunal deems fit. If no interest is awarded, the sum comprises only the principal. The significant words occurring in clause A of subsection 7 of section 31 of the Act are the sum for which the award is made. The sum for which the award is made. On a plain reading, this expression refers to the total amount or sum for the payment for which the award is made. The Parliament has not added a qualification like principal. They have, the legislature has not used the word principal in section 31(7).
Now, say supposing if we take into account the word sum, does it not refer to a definite amount?
Definite, certainly, Your Lordship.
Say supposing if any interest is awarded
Shall.
and it is to be charged till the date of realization.
Yes.
That means it does not refer to any definite amount. But then once we say sum, does it not refer to a definite amount?
Sum, your lordship, definitely. Sum, here the sum is explained. What does the sum means? Sum.
That is what, see, so what does the sum means?
Yes.
Sum means after calculation you arrived to something.
Yes.
That means once you come to a conclusion that this is the amount.
Yes.
You can say it is the sum. It
Sum.
is, okay.
Sum.
But then so long it is not calculated, it is not sum. Now in a word, if
No,
you
your
say
lordship, it is a sum.
the sum of which the award is made.
Arbitral tribunal or the court even does not make a calculation. They only lay down the principle that the sum will be the principal plus interest. Now, how much principal, how much interest, that is for the executing court to calculate. And this court will not sit over that calculation matter. Court will only determine whether the post-award interest is to be calculated only on the principal sum or it has to be calculated on the sum awarded, which is inclusive of principal plus interest accrued on the date of award. And when that is done so, it is not the case of the interest upon interest. It is not the case.
No, but then that proposition, you
Yes.
say that stand interferes by this judgment, interest upon interest.
Yes.
If you say your submission that that SLRO's case,
Sir.
whatever the observation is that,
Lordship.
basically that gets interfered with
Yes,
by virtue of
interfere.
paragraph 2
Yes,
of this
yes,
judgment.
it is totally gone.
So interest upon interest, that is a proposition in SLR case.
SLO.
So that goes.
That goes. That
Okay.
and
Now the question remains, but then it would not mean automatically that interest upon interest is allowed until
Yes.
and unless it is specifically provided in the decree, isn't it?
no, not required, Your Lordship.
that
Because
is
so
where-
far the
that is-
post-award
that is
interest
what-
is.
This is where this court basically is looking for more clarification.
Yes, Lordship, it is for this purpose we are here, Your Lordship. The the significant words occurring in clause A of subsection 7 of section 31 of the Act are the sum for which the award is made. On a plain reading, this expression refers to the total amount or sum for the payment for which the award is made. Parliament has not added a qualification like principle to the word sum, and therefore the word sum here simply means a particular amount of money. In section 31(7), this particular amount of money may include interest from the date of cause of action to the date of award. The Oxford Dictionary gives the following meaning to the word sum. Sum, if noun, a particular amount of money. Sum, if verb, the total amount resulting from the addition of two or more number, amounts or items. In Black Law Dictionary, the word sum is given the following meaning. In English law, a summary or abstract or a compendium or a collection, several of the old law treatises are called sum. Lord Halley applies the term to summarize the statute law. The sense in which the term is most commonly used is money, a quantity of money or currency, any amount indefinitely a sum of money, a small sum or a large sum. So here Your Lordship will say that it is not confined. Nowhere it says that the sum means the principal amount. Thus, when used as a noun, as it seems to have been used in this provision, the word sum simply means an amount of money, whatever it may include, principal and interest, or one of the two. Once the meaning of the word sum is clear, the same meaning must be ascribed to the word in clause B of subsection 7 of section 31 of the Act, where it provides that a sum directed to be paid by an arbitral award shall carry interest from the date of the award to the date of payment, that is the post award. In other words, what clause B of subsection 7 of section 31 of the Act directs is that the sum which is directed to be paid by the award, whether inclusive or exclusive of interest, shall carry interest at the rate of 18% per annum for the post-award periods unless otherwise ordered. Thus, subsection 7 of section 31 of the Act provides, firstly, wide clause A, that the arbitral tribunal may include interest while making an award for payment of money in the sum for which the award is made, and further wide clause B, that the sum so directed to be made by the award shall carry interest at a certain rate for the post-award period. The purpose of enacting this provision is clear, namely to encourage early payment of the awarded amount and to discourage the usual delay which accompanies the execution of the award in the same manner as if it were a decree of the court, wide section 36 of the Act. In this view of the matter, it is clear that the interest, the sum directed to be paid by the arbitral award under clause B of subsection 7 of section 31 of the Act is inclusive of interest pendent liability. This is very clear, Your Lordship.
Yes.
That it is inclusive of.
Paragraph 10 is very specific.
Very specific. At this juncture, it may be useful to refer to section 34 CPC also enacted by Parliament and conferring the same power upon a court to award interest on an award, post-award interest. While enacting section 34 CPC, Parliament conferred power on a court to order interest on the principal sum adjudged and not merely the sum as provided in the Arbitration Act. So your Lordship will find that where the legislature wanted that interest should be on the principal amount, they have specifically made,
So this is
as it is under section
34 of the CPC.
CPC. And same phraseology is not used so far section 31(7) is concerned. And there they do not say the principal amount. They say the sum. It is settled law that where different language is used by Parliament, it is intended to have a different effect. It cannot have the same effect. In the Arbitration Act, the word sum has deliberately not been qualified by using the word principal. Otherwise, it should have been the principal sum. Before it, if it had been so used, there would have been no scope for the contention that the word sum may include interest. In section 31(7) of the Act, Parliament has deliberately used the word sum to refer to the aggregate of the amount that may be directed to be paid by the arbitral tribunal and not merely the principal sum without interest. Thus, it is pertinent that wide clause A of subsection 7 of section 31 of the Act, Parliament intended that an award for payment of money may be inclusive of interest and the sum of the principal amount plus interest may be directed to be paid by the arbitral tribunal for the pre-award period. Thereupon, the arbitral tribunal may direct interest to be paid on such sum for the post-award period, wide clause B of subsection 7 of section 31 of the Act.
Now, this paragraph takes away the clarity which was there till paragraph 10.
Yes.
It again creates a confusion.
No, it doesn't, Your Lordship. Thus, it is pertinent that white clause A of subsection 7 of section 31 of the Act, Parliament intended that an award for payment of money may be inclusive of interest, and it may not be inclusive of this. We are talking about the pre-award interest. Pre-award interest. Interest. Principal plus interest may be directed to be paid by the arbitral tribunal for the pre-award period. Here it is concerned about the pre-award period. Thereupon the arbitral tribunal may direct interest to be paid on such sum for the post-award period, white clause B of subsection 7 of section 31. Here the sum is explained.
That is where the problem comes. If you see the language used,
Lordship.
in the award in question, the award which we are dealing with.
Lordship.
Now there it has not been done. Now if you see the starting paragraph of SL Aurora, see the language
Lordship.
used here.
No.
There you can make out
Yes.
that the pre-award interest is included,
Yes.
awarded, and that has been made as a part of the award.
Yes.
And thereafter it is further directed that the amount will carry further interest
Further interest.
till the date of payment.
Till the date of.
But then here the language is now, there is no use of such language in the present award.
No, Your Lordship, but it carries the same meaning. Here the language which is used
you see,
is
like
the
if you
till the
read-
payment is made.
Just a minute. If you read this paragraph 10,
Lordship.
now
Paragraph
it
10
basically
now.
paragraph 10 of this same judgment.
Lordship.
Now it makes, you see, like very clear. It is clear that the interest, the sum directed to be paid by the arbitrator under clause B of subsection C of the NSA is inclusive of interest pendent right.
Yes.
Yes.
There is no confusion, Your Lordship.
So if
so
you
far.
go by this,
Lordship.
paragraph 10,
And
that
come to
means
paragraph
that-
13.
that interest pendent right. Okay, now it doesn't say about pendent right is something different from pre-award, isn't it?
No, it is pendant light is pre-award.
It gets
Pre-award.
included. It
No,
gets-
even pre-reference award is included as a pendant light. Because earlier they used to award the interest pre-reference period, reference period, that is pendant light, then the post-award period. And under the old act, there was no such power to award interest under section 29
That is okay.
of the act. Then, Your Lordship, I come to paragraph 15.
Yes, please.
In fact, this is a case.
14 is not needed.
Lordship,
14 is not needed to be read up. No.
14.
14 is different.
14 is not related, Your Lordship. That is, rest is they are talking about the interpretation.
Yes.
I straightway come to the concluding para of Justice Bobde, paragraph 21.
Okay, 15 also is not needed.
Not so much. I can read paragraph 15. In such a situation,
No, it's up to you. Anyway, please.
just 1:15. In such a situation, one is reminded of the decision in Ganga Prasad, wherein this court held that where the language of the act is clear and explicit, the court must give effect to it, whatever may be the consequences, for in that case, the word of the statute speaks the intention of the legislature, Your Lordship. Then I take to Your Lordship the concluding para 20 of Justice Bobde, paragraph 21. In the result, I am of the view that SL Aurora case is wrongly decided and that it holds that a sum directed to be paid by an arbitral tribunal and the reference to the award on the substantive claim does not refer to interest pendent light awarded on the sum directed to be paid upon award. That in the absence of any provision of interest upon interest in the contract, the arbitral tribunal does not have the power to award interest upon interest or compound interest. Lordship will see that in the absence of any provision of interest upon interest in the contract, The arbitral tribunal does not have, this is the concluding paragraph, Justice Bobde is disagreeing with the view of S.L. Arora. Does not have the power to award interest upon interest or compound interest either for the pre-award period or for the post-award period. Meaning thereby the tribunal can award the interest upon interest. Parliament has the undoubted power to legislate on the subject and provide that the arbitral tribunal may award interest on a sum directed to be paid by the award, meaning a sum inclusive of principal sum adjust and the interest, and this has been done by the Parliament in the plain language. It's very clear, Lordship. Then that concurring judgment of Justice Sapre also may be looked into. I have had the benefit of reading the scholarly judgment of my Lord the Chief Justice as also my learned brother Bobde Justice. With great respect, I find myself in complete agreement with the reasoning and the eventual conclusion arrived at by Brother Bobde Justice, even though the judgment delivered by Brother Bobde Justice encapsulate everything of what is required to be said. I, however, looking to the point involved and very ably argued by all the learned senior counsel, wish to record my own reasons in addition to what has already been laid down. Reiteration of facts is unnecessary. The only question that arises for determination in the instant list is whether grant of interest by the arbitral tribunal under Section 31(7) of the Arbitration and Conciliation Act 1996 amount to granting interest on interest. That is the question, Your Lordship. The aforesaid question can be answered by a plain and simple reading of Section 31(7) of the Act, which reads as under. I am not bothering Your Lordship. I am to paragraph 26.
Mr. Jindal, we will continue in the second half, or maybe, no, do not know, because there is a division bench again.
Sure.
So, this court will have to rise now, and then we do not know at what time we come back.
So we'll assemble two.
There is a division bench.
Yes.
There is a criminal bench.
It's at 2 o'clock.
Then after that, over.
After they read the time permits. Or otherwise we will continue tomorrow.
Tomorrow.
Yes, ma'am.
What is better for you?
Let us continue tomorrow. My friend is here.
I'm here.
Let's continue.
The only thing.
You'll be here.
Yes, my lord. Only there are three judgments which are being cited before your lordship. One is S.L. Arora, second is Hyder, and third we are Morgan.
That is what.
Yes. S.L. Arora, my lord, is a judgment which says that the arbitrator has no power to award interest over interest. Hyder says that arbitrator has power to award interest over interest. S.L. Arora is set aside. The Morgan says that arbitrator has discretion to award or not to award interest. This is the judgment of it.
See, the court can give, may not give, may give, may not give.
Yes.
Now whether it is given or not, which will. That is the word used in the award that becomes vital.
Crucial. These three judgments are only indicating it's not that Hyder recognized the power of arbitral tribunal to grant interest over interest, because S.L. Arora said arbitrator has no power to grant interest over interest. That was set aside by Hyder.
Then, you see, if you see this Hyder,
yes,
then Hyder consulting, one thing is that,
yes, my lord,
that it has been observed,
yes, my lord,
that if any, you see, like
some
pre-award interest is given,
yes,
that gets included.
That Hyder was explained, because what has happened, Hyder was explained in Morgan, because this was the precise issue fell for consideration in Morgan. It was explained. I have a case law, my lord, that if whatever interpretation has been explained by the subsequent judge, that interpretation binds the parties. That is the case law. Whatever interpretation, because this is the interpretation of two judges, and that interpretation.
What Morgan says, that it will not be.
No, Morgan says that there is the power, the compound interest power is there as per Hyder. The tribunal has power to grant interest over interest, but tribunal has also power to exercise the discretion to grant or not to grant interest.
No, but then here it has been granted.
in
There
this,
is no dispute, it has not been granted. It has
in
not been
this,
granted.
no, so then,
But then whether that amount will get included with
yes,
the...
my lord, the tribunal has in our case granted simple interest on the principal amount. That is the thing. That is the crucial words, my lord. Those are the crucial, because ultimately it will turn on, as rightly observed, on the facts of the case, whether the tribunal has granted or not, and whether, and I will place when my turn come, those aspects, my lord.
You have not placed your written notes, isn't it?
I
You
have
not-
placed initially, my lord. Initially, at the
No,
beginning.
that is, you...
Yeah. I have placed, my lord,
There is a-
initial. I have placed it, my lord.
You have given us a
Yes,
writing.
yes, my dear.
It
Yes.
is now reflected in the order also.
We have given a small
I will.
gist. Even sir has given a small gist.
Yes, yeah, I will
That
place.
is, that is there, Mr.
I'll place it
Mr.
again, my
Jindal's
lord.
one is
I'll
there.
probably I'll check the file and I'll get it. Okay.
So far as Aegis one is concerned, there is
I'll place it.
only a compilation of case laws.
Compilation plus one written note was also
There's
done.
a small 4-page note.
I'll find out. Check it, no? Check it. The file may misplaced. Again, you do it now.
Anyway,
We'll place it.
Tomorrow, your lordship is having DB also, no?
DV will be there, Mr. Jindal, on every day.
Morning.
Because there are some cases which are fixed by giving dates. So there is no escape. Even if you want to, you see, like streamline the sitting and all, we cannot. So long that is not adjusted.
Should be listed on the top of the list,
Plus there is also uncertainty, so how long
Will come
the
into
constitution of bench will
It
be.
will come into
So we'll just say, the hard learned senior counsel appearing by the parties, the hearing to continue tomorrow. Just give date.
tomorrow.
We'll try. Tomorrow it will be all right for you. Let us finish it.
We will do it, my lord.
Let
Tomorrow
us
we'll
finish
finish
it.
it. Because it's in continuous flow, we can remember all the facts.
Otherwise,
Yes, we also.
we may forget.
We are also having difficulty. Again, we have to burn midnight oil for reading all these judgments.
But his meter is on, there is no problem.
No meter. Ultimately, you have meter will be on next day also.
Probably yours also, Mr. Jindal.
I am at the receiving end, lordship. I am at his mercy.
I'm at you.
Yes, Mr. Chakravarti. Miller, I beg to make a mention, Miller. Item number 14, Miller. It may come up tomorrow, Miller. That was also. Otherwise, there are many matters in the list.
Well, this matter was substantially heard. Only the government was supposed to bring the annexures to the FIR. Only that.
I have filed. I have done.
So
Okay.
tomorrow I think the matter may be closed.
Okay, item 14 also. Yes. That is that quashing.
Yes.
Your Lordship.
That's also item 40. All payment with parties. List tomorrow.
Item 19 and 20, Your Lordship.
Yes.
That may come up after vacation.
19 and 20. Yes, madam, you are there.
Yes, for the petition.
Yes, Mr. Deb,
These are question petitions may be taken up after vacation.
made by Mr. Jirwa, London Council applying for the private respondent.
Number respondent to.
Respondent 3, man.
Yes, list is matter after 2 weeks. This 19 and 20.
19 and 20, man.
Obliged.
Much obliged.
It's there.
It is there. Please keep it in the file. Okay. Keep it together with Jindal's thing and also that's separated.
Madam, we'll be filing another one also once we finish our side. Same, 6 page.
The
small,
extended
small.
one.
Just like what we are covering up. Not much. This is 4 page, there will be only 6.
Mr. Khera, you see, issue is very much on that.
It's limited, my lord.
No, that is where this court may look for further
My lord.
clarification.
And my lord, the other, once the issue of on the law is done, on factual aspect, as in, my lord, that wrong interpretation goes on, where 3 times the interest was added into the principal and reinterest.
No, see, once it is settled, then you see that calculation also will be subject to what we observe.
My lord.
Yes, there are other matters. There will be other matters, single bench matters. This will be the last thing. Yes, thank you.
Hello.